Companies Act, Section 202, Compensation for Loss of Office of Managing or Whole-Time Director or Manager. Section 202 of the Companies Act, 2013 establishes provisions regarding the payment of compensation to a managing director, whole-time director, or manager in the event of the loss of office or retirement. This section seeks to regulate the circumstances under which such payments may be made, the conditions under which they are prohibited, and the limits on the amount of compensation. The aim is to ensure that these payments are fair, transparent, and reasonable, taking into account the interests of the company and its shareholders. 1. Payment of compensation. Payment to directors or managers for loss of office. Subsection 1 of Section 202 allows a company to make payments to a managing director, whole-time director, or manager as compensation for loss of office. This includes payments made in consideration for retirement from office or in connection with such loss or retirement. However, it is important to note that these provisions specifically apply to managing or whole-time directors or managers and not to any other type of director, such as independent directors or non-executive directors. These payments are meant to compensate individuals for the termination of their employment or office with the company, particularly if the termination is involuntary. This can include severance pay or other forms of retirement benefits, provided the payment is aligned with the terms and conditions outlined by the company and as per the relevant legal framework under the Companies Act. 2. Prohibited cases for payment. A. Resignation due to company reconstruction or amalgamation. Subsection 2 outlines specific situations where no payment shall be made under subsection 1. One of the key exceptions is when the director resigns due to the reconstruction of the company or its amalgamation with another company. In such cases, if the director is subsequently appointed as a managing director, whole-time director, manager, or other officer of the newly reconstructed company or the body corporate resulting from the amalgamation, they are not entitled to receive compensation for loss of office. This ensures that directors who continue in a similar or equivalent role in the new structure of the company or its amalgamated form do not receive additional compensation for retirement or loss of office. B. Resignation not due to company reconstruction or amalgamation. Subsection 2(b) further clarifies that no payment shall be made when a director resigns voluntarily or for reasons other than the reconstruction or amalgamation of the company. This provision prevents directors from receiving severance compensation if they leave their position under circumstances not related to company restructuring. C. Vacating office under Section 167(1). Subsection 2(c) specifies that no compensation is payable if the office of the director is vacated under subsection 1 of Section 167 of the Companies Act. This refers to cases where the director is removed from office due to certain legal or regulatory violations, such as the failure to attend board meetings or other disqualifications, thereby disqualifying them from receiving compensation. D. Company in liquidation due to director's negligence or default. Subsection 2(d) also prohibits compensation if the company is undergoing winding up, whether voluntarily or by an order from the tribunal, and the winding up is a result of the negligence or default of the director. If the director's actions have contributed to the company's financial troubles, they will not be entitled to severance payments upon their departure. E. Director's guilt in fraud, breach of trust, or gross mismanagement. According to subsection 2(e), no payment shall be made to a director who has been found guilty of fraud, breach of trust, or gross negligence in managing the company's affairs, including any related companies like its subsidiaries or holding companies. This ensures that directors who fail in their fiduciary duties or engage in misconduct are not rewarded with compensation for losing their office. F. Directors' role in terminating their own office. Subsection 2(f) further stipulates that if a director instigates or is directly or indirectly involved in the termination of their own office, they are also disqualified from receiving compensation. This provision prevents directors from creating circumstances that lead to their own removal, with the expectation of receiving financial compensation as a result. 3 limitations on compensation. A. Maximum payment based on remuneration. Subsection 3 imposes a limit on the amount of compensation that can be paid to a managing or whole-time director or manager. The payment shall not exceed the remuneration that the director would have earned if they had continued in office for the remainder of their term of office or for 3 years, whichever is shorter. This is calculated based on the average remuneration the director received during the 3 years immediately preceding the date they ceased to hold office, or during a shorter period if the director was in office for less than 3 years. The provision ensures that the compensation is reasonable and proportional to the director's actual earnings over a recent period, preventing excessive payouts. B. Payment prohibited if company in liquidation. The provision also includes a proviso under which no payment shall be made to the director if the company begins winding up, whether voluntarily or through an order of the tribunal, especially if this occurs within 12 months after the director ceases to hold office, and if the company's assets are insufficient to repay the shareholders' capital contributions. This ensures that in case of company failure or liquidation, directors do not receive compensation at the expense of the company's creditors or shareholders. 4. Payment for other services. Subsection 4 clarifies that the provisions in Section 202 do not prohibit the company from making payments for other services rendered by the managing or whole-time director or manager in a capacity other than their position as managing director, whole-time director, or manager. For example, if the director is performing other roles within the company, such as consulting or advisory services, the company can remunerate them separately for those services, provided these payments are not classified as compensation for loss of office. For more details, contact us.